Joining us this evening is Moana Tuwhare, a former treaty lawyer and who I'm told has worked on the Ngapuhi claim for the best part of 2 decades. Also worked on the Maranga Mai report, which we might touch on shortly through the conversation. Welcome to the show, Moana.
Tēnā koe, Pat. Kia ora.
Very excited to have you. Could you maybe, I've given you a small introduction, could you maybe explain to the audience a bit more about who you are and how you've been involved, especially to do with this Ngapuhi claim?
Yeah, sure, no problem. So on my Māori side, I am from Ngapuhi. So we are from various hapu from the Confederation of Ngapuhi. And I had the privilege and honour really to be representing different claimant communities from within the iwi throughout the hearing process, which also led me to take up a role as coordinating counsel during the stage 1 of the hearing process of the Waitangi Tribunal. So that involved being very, very actively, heavily involved in the bringing together and working as a unit, really, as a whole iwi approach to the hearing of that claim about whether or not we ceded sovereignty, and the finding, of course, that we didn't cede sovereignty when our rangatira signed the treaty. But yeah, so I've got a long background in terms of my whānau legacy as well, being a direct descendant of signatories to Te Tiriti and to He Whakaputanga. So just one of the many in a long line of people who have been holding the line, if you like, for our iwi.
I think what we'll do, if it's okay with you, is I saw this on YouTube in the weekend. It was a story from One News, and I thought it's only like 3 minutes. Maybe what we could do now is we'll watch this story together, because this kind of gives a bit of a nutshell as to why I've asked you to come on and have a chat with us, and then we can delve into it. We all good with that?
Great.
So this is, I think, from Saturday's One News. It might have been Friday, I don't know, but certainly in the weekends, it was post our last show. Let's have a look at this together, because honestly, I saw this story and I went, shit, this feels like the biggest piece of news in New Zealand at the moment. I think, especially when you tie it into the rumblings that this current government is making as well, this feels massive. It doesn't seem to be as massive as I think it is in the media. I'm not sure why, but I really wanted to give our audience a good chance to get a good depth of what this all means and how it's going to pan out from here. So anyway, let's get to Wendy Petrie and the One News team from the weekend and have a look at the story we're going to talk about.
Ngāpuhi, the country's largest iwi, is welcoming the presentation of a landmark report detailing treaty breaches. It's taken decades to finish, following an inquiry by the Waitangi Tribunal, which considered 500,000 pages of evidence. Its key recommendation for the return of all Crown-owned land in Northland to Māori. Te Anua Hurihanganui reports from Waitangi.
It's the day Northern Māori, including the country's largest iwi, Ngāpuhi.
You have to excuse me, Moana. Sometimes we interrupt the news to do this. Were you up there for this presentation?
No, I actually wasn't. I have been very selective about what I'm giving my energy to these days. So I wasn't present. I was in recent communications with the tribunal, the release of the report. But just as an aside, the report was actually unofficially, well, they call it the pre-publication version, was actually released just before Christmas of last year. So we've had it for over a year. So this was the public handing over of the report, which really was to recognise the claimants rather than the lawyers, and the the key people from within Ngāpuhi that have led our position on this, and the many who have passed on, because there's so many of our kaumātua and kuia that have died since beginning the hearing process up until now. So you'll see a shot a bit later on in this clip of all of the photos of our kaumātua and kuia and people who have passed during the process.
Yeah, I think you see people carrying photos and stuff as well. So I'm assuming that's all a part of it. Okay, we'll play some more of the story.
Have been waiting for.
That shot there.
The Waitangi Tribunal arriving to present its 2,000-page report, laying bare the Crown's treaty breaches across Northland, stretching back to 1840.
20 years we've been at this game. Still got nothing. We're getting there.
Please, take this document, place it on the table before our budding Prime Minister and tell him he's got to read it.
Following the signing of the Treaty of Waitangi, the report describes the Crown as the aggressor, using military force to impose sovereignty over Northern Māori. The military instructed its forces to spare no rebels, destroying homes, property, waka, and eventually taking 2/3 of Ngapuhi land.
Largely, the hapu of Ngapuhi are landless.
Central to the first part of this report was the question, did Northern Māori cede sovereignty?
And concluded that in February 1840, the rangatira who signed Te Tiriti did not cede their sovereignty.
That means they never agreed the New Zealand government had the authority to govern them. They did agree to share power so Pākehā and Māori could govern their own people, confirming what Ngapuhi have always believed.
The number of years that's been contested. And we've stuck to our guns knowing that our history has informed us, our whakapapa has informed us.
The report says, yes, what the tupuna said in terms of ngā hara, in terms of the things that were done to Ngapuhi, was correct.
2 key recommendations have been made for the return of all Crown-owned land in Northland to Māori and for the Crown to enter talks about reworking our constitutional framework.
I think governments will be reluctant to accept or even start talking about these sorts of recommendations because it would be the death knell for those political parties.
It's a conversation the Treaty Negotiations Minister has told One News he's open to, and a long time coming for a people who've endured so much. Te aniwa hurihanga nui, One News.
So that was the news item from the weekend, Moana. Now, just to explain to us a bit more, you said the pre-publication had been released. Does that mean that this is sort of the official release? Like this is now out in the public sphere to be talked about, debated, worked through?
My understanding is that anybody could access the pre-publication report, but for the fact that nobody knows that it existed. So all of the tribunal reports are available on the website. The pre-publication report is really just means that it hasn't literally been put into a hard copy and into the bookshelves and libraries and what have you. This was the official handover of the actual physical book, 2,000-page report, and you would have seen them in kete and handed physically over to those key people from each of the regions, key kaumātua who have led this whole process within their regions and amongst the claimant community. Yeah, and I mean, that takes a fair bit of organising. So my understanding is that there's been back and forth in terms of discussions about the best way to achieve the official handover of the physical reports and where that should be located and so on and so forth. Because, you know, Ngapuhi on a matter of scale, we're talking about 400 plus claimants, who filed claims that got heard as part of this process. And we're talking about over 110 active hapu. And, in terms of population size, we're the largest iwi by far, almost twice as big as the next largest iwi. So the scale's a massive thing in terms of coordinating this type of, public ceremony and process to get around everybody, get everybody's feedback and do something that will, ultimately be the right thing to do by the claimant community. In a handover like that. It is a very significant finding for us, but we have had the report and have had the ability to read through it for the better part of 11 and a half months now.
It seems to me, and you'll have to apologise, you're speaking to an ignorant Irishman here, but it seems to me that most Māori, one of the biggest points that they want to be clear is the whole ceded sovereignty part. I mean, not speaking on behalf of all Māoridom, but do I get that right? Like a lot of people, a lot of iwi, a lot of hapu are really trying to say we never ceded sovereignty. And is this like one of the first public official announcements that this iwi did not?
No, so the stage 1 report, so this is part 1 of stage 2 that just got handed over in the weekend. But the stage 1, which the report for which was released in 2014, was the tribunal's decision around the meaning and effect of He Whakaputanga, the declaration, and Te Tiriti as at 1840. So the stage 1 report in 2014 is when the tribunal effectively released its finding that the treaty was not a cession of sovereignty, and that the rangatira never agreed through the signing the Treaty of Waitangi to cede their sovereignty to the Crown. And what they in fact agreed to was a relationship between themselves as rangatira retaining their tino rangatiratanga on a relationship with Hobson, by which the rangatira would continue to effectively conduct their hapu affairs as they always had, according to their own laws and political systems and jurisdiction and so on and so forth, and that Hobson would have jurisdiction or a function of government and jurisdiction to regulate settler behaviour, and that where the two spheres of influence is how the tribunal puts it. That the rangatira would retain their sphere of influence. Hobson was granted a sphere of influence called kāwanatanga, and that where those overlapped, that the two parties would come together and work out on a case-by-case basis, depending on what the situation was, how best to work together. And that was a 2014 finding, which was being reinforced by the release of this latest report. This latest report takes us from 1840 up to 1990, so there's still another part to come. To 1900. So the first 60 years following the signing of the treaty.
But those first 60 years are quite important because that talks about what was done at the moment, like at the moment of signing. So I would assume that's a really important part. I'm also really confused. Now, there might be an easy answer to this, but you speak about Hobson. So I think straight away of the Don Brashes of this world and the Hobson Pledge. And I think about, David Seymour and these people who are all saying, Māori absolutely ceded sovereignty. Yet from what you're saying, is that for the past 10 years, it's been known by everybody and it's been clear to everybody that they did not cede sovereignty. How does that work itself out, like in public discourse, like how New Zealand's actually going to operate from here going forward?
That's a very complicated answer, only because, it's simple to us. If I give you a Ngapuhi view of the world, that might be a little bit more straightforward. But the fact of the matter is that if we took a strictly English language version of the treaty, interpretation to the treaty and application of the treaty, then we are looking down the barrel of absolute undisturbed possession of all resources are to be retained by Māori unless we have willingly given that up, which means we control all of the water, we control all of the land, all of the resources that we would not willingly give up, it remains in Māori control. And some of those resources obviously have long been in the possession of non-Māori in the country, but some resources like the water are not. And so if you want to take the position that co-governance is a Pākehā compromise, you should really be looking at it from the other end of the spectrum, which is actually that's Māori compromising to co-govern a resource that we never agreed to give up in relation to the water. So that's a much more opposite end of the spectrum, then most of us would really be prepared to take it, because what we are hoping to build in this little nation of ours is a environment in which all people, no matter who you are, where you're from, have the ability to be part of the system in a really meaningful way. So that's where those two, co-governance is one word for it, but where the two spheres of influence overlap. Right, so that overlaps in so many realms across so many ways now in 2023, and will continue to overlap in so many ways in the future. We are committed as Ngāpuhi and as descendants of those original signatories, and to the vision that they held in 1840, to a strategic partnership and alliance here. We are committed to that relationship, and we're not going anywhere. We'll still be here in 180 years, and we'll still be here in 800 years, and the treaty partner will come and go, probably on a 3-year cycle if we're lucky. This treaty partner will be out in 3 years, so will the people, in terms of immigration and the sort of ebb and flow of the wider people of Aotearoa. So but to go back to your question, what does it mean? Well, for us, it means that we get the ability to make the calls for ourselves. The Māori Health Authority was an attempt to basically provide Māori with the necessary resources and infrastructure to deliver on Māori health in the way that we saw fit, because we honestly and truly believe, and the research shows that by Māori for Māori is a much more effective approach. And so we will hold on to the fact that not only did we not cede sovereignty and continue to push that in terms of a constitutional discussion around the way in which decisions get made in this country, and the way in which the power continues to be unbalanced, and how do we rebalance that relationship so that there isn't this constant imbalance and interfering with our ability to get on with doing the best we can for our people. So I think it's a fairly straightforward thing from our point of view. We respect Pākehā ability and right to do as they see fit for their people, or for our people, because many of us are also Pākehā, but we don't often enjoy the same respect coming our way. So that's really part of the problem. And it is such a political football, but we've been here, done that quite a few times now. So it's not unexpected. It's not like we don't know what we're in for this time round, and potentially even into the future. But I think as our evolution as a nation requires us to teach our people, and I'm talking about all New Zealanders, to have a good education in our civics and have a really good education in our history, because part of the problem with the very extreme / racist views that are coming, and rhetoric that's coming out of the government at the moment is very much based on a portion of the population who continue to be very uninformed about our history and particularly our, the treaty and what it means.
A little side note question, because you brought up the Māori Health Authority. As you're saying, Māori didn't cede sovereignty, i.e. Māori have and I sometimes think about, and I don't mean to belittle it or take it too kind of lightly, but the treaty is being a contract. Like if we talk about like contract law, that seems to be an easier way for some people to understand it. Now, if I'm wrong, correct me, but if the contract says Māori have the right to determine their own path and their own sovereignty, does that therefore mean the cancelling of the Māori Health Authority is in breach of that contract, in breach of the treaty, in your opinion?
Yeah, absolutely. Yep, that's a very plain way of putting it, and absolutely the cancelling of the Māori authority is a breach of the treaty, and there's no doubt that a claim to the tribunal that claims that is going to win, if we still have a tribunal to claim to. So that's really where the problem might lie, is that we may no longer have anywhere to go in terms of a system that will hear us and our vision and our if the tribunal is removed or tinkered with in some way, shape or form, that would be an absolute disaster from my point of view. The tribunal has spent 40 years in the pursuit of analysing all of the claims that have been brought before it. These people are smart. These are some of the sharpest minds in the country, and with a range of backgrounds and experience. So you don't just have a judge like you might in the mainstream system who's got a background in commercial law or something along those lines. You've got a judge, you've got an expert in tikanga Māori, you've got historian members, you've got all sorts of skills and knowledge amongst them, and even the mainstream court system will defer to the tribunal and its findings, both findings of fact and often look to its recommendations in relation to where the justice might sit on a particular issue.
Right.
If it is raised in such a way that the mainstream court system has to consider that, or should consider that, they do. So they are considered the experts, and they're not just the experts in a national sense, they're the experts in an international sense in relation to how you reconcile and provide for Indigenous rights in a colonised system. And they've, many of the principles of the treaty that have been articulated by the Waitangi Tribunal have been adopted by, the United Nations, for example, in relation to the United Nations Declaration on the Rights of Indigenous People.
Yep.
And, there's been lots of borrowing from the New Zealand example in international arenas. So the tribunal is an amazing forum, and let's not forget that they are not only some of the sharpest minds in the country, but they go through an inquiry, a really thorough inquiry process. So the Crown is represented always. They turn up with all of their, lawyers and all of their witnesses that, also astute, bright people, and they examine on a very, very, minute detail type of thorough basis. Then that's why it takes so long. It simply takes so long because there is literally hundreds and hundreds of thousands of pages of material to get through, hundreds and hundreds of witnesses to get through. The forum is open, so anybody can turn up and listen to, how it's conducted. Anybody can access the information if they want to online. So, it's a very transparent and thorough process. To knock, often the tribunal reports, because their findings are mostly recommendatory and they aren't binding on any government, often the reports get shelved, and often they don't go further. But the Māori Health Authority was directly related to putting into place recommendations made by the Waitangi Tribunal on the state of the health system and how the health system was not delivering for Māori in terms of outcomes and what could be done instead. So going down to the tax and the nuts and bolts of how does it get funded, how does the mainstream system get funded, can a different way of that happening actually achieve better results? And overwhelmingly, all of the health experts that rolled into that inquiry to give evidence, the vast majority were in support of Māori being able to determine the best way forward, because Māori health practitioners know what works and what doesn't. yeah, so that's how we ended up with a very concerted effort by the last government to actually implement the recommendation of the tribunal through that health authority.
Hey, thanks for joining us so much. If you've got time for one more quick question, it's probably one of the bigger questions that the general public will be wondering as well. One of the recommendations, or one of the major recommendations of this latest report from the Waitangi Tribunal, is to return all Crown-owned land to Ngapuhi. If that was now, I guess what I heard you saying then is the government is obviously not bound to what the Waitangi Tribunal rules. It's a recommendation, but should that recommendation flow through and be carried out as it's suggested in the report, what does that look like? What does that look like, in Northland for all the Crown-owned land to go back?
Yeah, well, actually, interestingly enough, it doesn't look like very much. The Crown doesn't own much land in Northland.
Right.
So on a practical sense, the Office of Treaty Settlement, or Te Tiriti as they're known, and apparently we're allowed to continue to call them Te Tiriti because they're predominantly there for Māori. So Te Tiriti have already provided us with information about where all the parcels of land in Northland sit for the purpose of negotiations or pre-negotiations, and there isn't a lot. And because there isn't a lot, the last government set up a Māori investment, a Ngapuhi investment fund for our iwi in recognition that there wasn't a lot of land to give back in a settlement process. And that fund is being actively invested by a board that's been put together for the purpose of buying more land in Northland for the return to Ngapuhi when we get into negotiation and settlement and into the settlement phase. So we are able to have input into what parts of land, what land is bought by this investment fund and for whom it might be returned eventually. Right. And that's really on the back of a recognition that we've been prevented from settling due to Crown policy that has tried to sort of pinhole us into a process that just simply doesn't work for us, and B, the ongoing delays to a settlement process. So we're well past one generation since the first settlements happened. And we're not even really close to getting off the starting blocks, unfortunately. Well, in some ways it's a good thing, in some ways it's a bad thing. But for us, our constitutional position and the relationship between rangatiratanga and kāwanatanga is, really important aspect of any settlement negotiation discussions that I don't think the Crown really has their head around in terms of how that might shape up in a settlement process. And so just simply handing back land is not going to be enough. And that was the other part to the tribunal's recommendation, was that, there needs to be some concerted effort made in discussing where Ngapuhi sit constitutionally and how we will, how that will be supported moving forward. But to going back to the land issue, the Crown has recognised for quite a while now that there's not much land to give back in Northland, so they've tried to do something about that.
Hey, one last question. I should have stopped it already, but just thinking about government, thinking about what's happening at the moment, hearing you say things tongue in cheek about we're allowed to keep calling it that at the moment. David Seymour is being very loud at the moment about nobody knows what the principles of the treaty are, so we need to throw it to a referendum. As someone who is obviously far more of an expert than I am, or potentially anyone who's watching right now, how would you define the principles of the treaty?
Well, I mean, the principles of there's a set of the principles of the treaty that have been articulated over and over and over again for the better part of 30 plus years. And it doesn't take, any genius or rocket scientist to find out what they are. There's lots of information out there if you want to find it. But I think the reality is that people have not bothered to do that, right, for whatever reason. And I think our education system continues to fail us, and not just at a primary and secondary level, but at a tertiary level, because we continue to produce graduates out of New Zealand universities and tertiary institutions all over the country none the wiser as to what these principles are, but they're actually easy to find out. And just to very briefly run down for you the 8 key principles that were identified by the Te Paparahi o Te Raki Tribunal in relation to the report that just got released on the weekend, or publicly handed over on the weekend. So there's the principle of tino rangatiratanga, the principle of kāwanatanga, so obviously that's Article 2 and Article 1 that those principles fall out of. The principle of what they call te hauruatanga in te reo Māori, but it's basically the principle of partnership, where the 2 spheres of power overlap or influence overlap. The partnership approach must be taken. The principle of mutual recognition and respect, the principle of active protection, the principle of mutual benefit and the right to development, and the principle of equity, and finally the principle of redress. So where a breach has been is clear through legislation, policy or action or omission of the Crown, then Ngapuhi have the right to redress. So, I mean, those are 8 of principles that have been consistently repeated in different ways by different tribunals for a long time, and also by, you know, our own court system going back as far as the late 80s. So, yeah, they're not undefined. And I think the key thing about them, you know, about decision makers not being sure about which principles apply and when, I think the issue really is that the different contexts will require different sets of principles to apply. Yep. So it is for a decision maker to determine in any given context what are the appropriate set of principles that should apply in that particular circumstance. So I don't think making them mandatory in certain circumstances is going to help anybody. I think that's going to make it harder and worse. And I think that the way we have been doing it, where decision makers, when they're faced with an issue and have to weigh up, you know, all of the matters before them that would relate to any particular issue for Māori or for non-Māori in relation to a Māori issue, that they're, you know, that it's for them to determine what principles apply, and, you know, with a long established sets of principles to draw from. So I hope that helps.
Oh, you probably just saved the country millions of dollars, because we don't need the referendum now, the so-called referendum.
You do not need the referendum. I do think we need to get a bit more clear about some of this stuff. You know, it needs to be understood by the public. It needs, you know, our general population deserves the you know, the respect, if not, you know, for any other reason, of being informed about this stuff. Like, this is not something that anybody should have to be humming and hawing and unaware of. But I do expect more from career politicians, like, you know, the ones that have know full very well where to find this information and have all of the advisors on hand to provide it to them if they don't.
Well, and obviously it's because David Seymour is dog whistling to a particular audience, because he's not calling. We've never, as a country, had a chance to hold a referendum on the retirement age, but he's not pushing that. Whereas as a country, we've never had a referendum to have our opinion known about the tax brackets, but he's not pushing that. He's only pushing the one about the treaty for obvious reasons. It's he's speaking to an obvious base, unfortunately.
Yeah, well, I've been thinking about that, and I think that that, you know, in terms of a strict interpretation of the treaty, that given that it's going to be largely Māori children that are paying their superannuation when they retire, in terms of the population and the way that's moving, that, you know, it's, if they want to keep peddling racist rhetoric, then let's cut their pensions for just for on the basis of, you know, that's our valuable taxpayer money that's largely going to be made out of, you know, workers of Māori descent. Anyway, not just Māori, obviously, but you know, it's just one of those things that, I mean that tongue in cheek. I'm not serious about it.
Yeah.
In awful form, but yeah, I just think that we need to learn to treat all people with dignity and equity. And you're absolutely right that in very many other laws in this country, we categorise humans either by age or by competence or, you know, all sorts of ways that we categorise humans. And that it's a very well understood international human rights norm for Indigenous rights to be recognised as human rights. So when they default to this equality under the law rhetoric, they are actually missing the point on a number of levels. And then at some point you got to ask, is this just intellectual dishonesty, or is this just pandering to a particular portion of society who have a vested interest? And I think given that these aren't stupid people and that they have lots of resources to make sure that they get fed good information, that they are just pandering to a particular part of our society that has not got our general best at heart. And we should not buy into the division. We should stay united as a country around this, and just make it count where it hurts, and that's in the voting booth in 3 years' time. This is a one-term government. Sing that message loud and clear, people.
Moana Tuwhare, thank you so much for joining us this evening. It's been amazing, and I'm sorry that I took up so much more of your time than I said I would, but it's just been gold, so we appreciate it.
No problem at all. Thank you for having me on. I appreciate that.